Section 7 of the Israeli Notaries Law, 5736, 1976, clarifies that the first power and authority an Israeli notary has is to authenticate signatures. But this is not the sole field of authority of the notary, who is also authorized to witness and authenticate notarized translations of documents, notarized copies of documents, notarized wills, irrevocable powers of attorney in favor of mortgage banks, powers of attorney in favor of non-lawyers, notarized prenuptial agreements, etc. Signature verification or certification on a document by a notary is mandated by Israeli law in a number of situations. These include an irrevocable power of attorney in favor of a mortgage bank, empowering the bank to register the property to be mortgaged in the borrower's name, and later also to register the mortgage in the event that the borrower fails to perform these activities. This enables the bank to guarantee the payment of the mortgage. An irrevocable power of attorney in respect to a new property, for example an apartment, in favor of a building contractor, empowering the contractor to undertake all of the registration formalities at the relevant land registration bodies. For example, registering the building as a cooperative house, a Bait Meshutaf, in the land registry. In view of the tremendous importance of these powers of attorney, and because the rights of third parties are dependent on them, they will be irrevocable, meaning that they cannot be cancelled after they have been made. The special notarial stamp and seal on these documents is designed to prevent their forgery. By contrast, in other cases, which do not have such a significant impact on those involved, a regular, non-notarial power of attorney may suffice, for example, for the municipality or for cellular phone companies. A power of attorney in favor of a relative or other third party, empowering such other person to act on behalf of the donor of the power, whether in general or for a specific purpose. For example, to undertake banking transactions, to take any legal steps necessary to collect debts owed to the donor, to maintain or operate any business of the donor, to enter into binding contracts, to perform any other function, for example, collecting mail on the donor's behalf. Moreover, if a legal document is being signed in Israel to be used overseas, the foreign country will usually require the document to be witnessed by an Israeli notary rather than a regular attorney or solicitor. This is because the notary's qualification is recognized abroad and the notary's signature can be verified. Common examples of overseas transactions that need a notary include medical professionals applying to work abroad, granting power of attorney to a title company to buy or purchase land on one's behalf in the USA, or according an overseas law firm legal authority to sue a defaulting tenant for unpaid rent on property one owns overseas. For the purpose of a notarial certification of signature, the signatory must present to the notary original means of identification at the time he or she signs the document. Acceptable means of identification include a national identity card, one's Teudat Zehut, or passport. The notary is required by law to confirm the identification of the person signing the document, hence the need for original identifying documentation.